Will the recessed Housing and Land Use Committee meeting of July 29, 2026 please reconvene? The time is 9:10 on August 10th, 2026. I am council member. That counted though what I did, right? Okay. I am council member Tamara Paultin, and before this meeting recess, the committee appointed me as temporary chair. The committee chair and the committee vice chair are not present today, so I will continue acting as temporary chair. Members, in accordance with the Sunshine Law, please identify by name who, if anyone, is in the room, vehicle, or workspace with you today. Minors do not need to be identified. Committee Chair Nohe Uu Hodgins is excused. Committee Vice Chair Kawanoi Batangan is excused. Councilmember Tom Cook, Aloha Kakayaka.
Aloha Kakakiaka. I'm in our Kihei regional office, and in my alone on my side. Jared, our EA, is in the front, and there's currently no testifiers in Kihei office today.
Thank you. Next up, we have Councilmember Gabe Johnson. Aloha Kakayaka.
Aloha and good morning, Chair, Council Member, community members. There's no testifiers, or I'm alone on my side of the office here, and I'm ready to work. I don't see anybody, there are no testifiers here on the Lanai District office, and we're ready to work. Thank you, Chair.
Thank you. And just a reminder to the viewing public that testimony was closed at the last meeting, so we won't be taking any more oral testimony. We do continue to accept written testimony, and I think we're up to 68 written testimony in the e-comment as of when I last checked. Next up, Council Chair Alice Lee. Aloha Kakayaka.
Aloha kako.
And next up, Councilmember Keani Rollins Fernandez. Aloha Kakayaka.
Aloha kakayaka, Chair. Aloha kakayaka kako. My Molokai nui ahina. I'm at my private residence alone. Kids are back at school. And there are no tests. Oh, never mind. I'm alone. Ready to work, Chair.
Thank you. Next up, Councilmember Shane Sinensi is excused. We continue to send him, his ohana, his staff, our aloha. And I believe Councilmember Yukile Sugimura is en route and possibly listening on the phone. So remember, we got 5 of us. If you're gonna step away or turn off your camera, let me know before you do that. Thank you. From the administration, we have with us the Deputy Planning Director, Anna Lillis. From the Fire Department, we have CIP Coordinator, Michael Arsuni. From the County Real Property Tax Administrator, we have Carrie Stockwell. From the Director of Water Supply, we have John Stuffelbein. From OEB Resources, we have Director Kapono'ai Molitao and Deputy Director Kikai Robinson, as well as Principal Archaeologist Dr. Janet Six, Archaeologist Jay Raposa, Hawaiian Language Specialist Keahi Johnson, and we have Deputy Director of Agriculture, Koa Heva Heva, and maybe if he has to step away, Mia Hunter will step in. Our Deputy Corporation Counsel today is Nahulu Nunokawa. We also have with us today the individuals we designated as resource persons, including the project consultants from Munekio Hiraga Planning Consultants, Mark Alexander Roy and Hoku Kruger. From AHL, Architect Garrett Horimoto. From AECOM Engineers, Diane Kodama and Jessica Samura. From Keala Pono Archaeological Consulting, Cultural Consultant Gina McGuire, and from Mailelani Design Landscape Architect Vivian Arita. Kaneali'i Williams is also a resource person for this meeting. Also with us is our HLU committee staff. We have Legislative Attorney Carla Nakata, Senior Legislating Analyst James Kruger and Zach Stackhouse, as well as Committee Secretary Jennifer Yamashita, and no Assistant Clerk because testimony is closed. We have one agenda item on today's agenda, Bill 89, 2026, Bill 90, 2026, and Bill 91, 2026, which are the District Boundary Amendment, Community Plan Amendment, and change in zoning for a 6.097 acre portion of tax map key, paren 2-7-007:008, Hamakua Loa, Hawaii. Haiku Fire Station, HLU 17 is the agenda item. Members, as a reminder, before us today, these bills are related to the proposed Haiku Fire Station project, which will be on an about 6.1 acre portion of a 27.9 acre county-owned property identified as tax map key paren 2-7-007:008 in Hamakua Loa, Hawaii. Bill 89 specifically would amend the state land use district classification from agricultural district to rural district. Bill 90 would change the Paia Haiku Community Plan land use designation from agriculture to public quasi-public. And Bill 91 would change the zoning from agricultural district to P1 public quasi-public district. And that's just for the 6.1 approximate portion of the parcel. We have already closed oral testimony on this item. Written testimony will continue to be accepted. Members, I did check with our Deputy Council Services person, and I want to run this meeting a little bit different, and she said I can because I'm the chair. So I will let you know when we get into discussion, but there's a lot of information to go through. And do feel free to raise your hand if you have any clarifying questions. But I just wanted to set out some of the information first before we get into discussion. Is there anyone here that has a problem with that of the members? Okay, I
No problem.
did do extensive research, so I don't want to waste everyone's time too much with other stuff. Okay, so just want to clarify some things. From some of the testimony received, it seems as though there may be some misinformation. And so the first things that I wanted to clarify or get clarified either from our resources or someone is that no federal funds will be used. We had federal funds in a previous budget because we anticipated getting federal funds, and they've been pulled from the project. And then I guess there was a thought that we were going to use some of the 1.6 billion CDBG-DR funding. That's not the case because the CDBG-DR funding has to be used in accordance with the plan that was sent to HUD, and that's not part of the plan. So we're going to be using all county funds for this project, so there's no federal funding. Can some of the resource, anyone who knows, can they confirm that is accurate? Maybe Mr. Arisumi or Corp Counsel? Okay, Mr. Nunakawa?
I can't speak to it personally, but that is what I was told from fire.
Okay, I do see Mr. Arisumi raising his hand. Has he been unable to speak? Okay, just unmute yourself, Mr. Arisumi, and you can, if you can confirm for us that there is no federal funds being used.
Good morning. Yes, I can confirm there are no federal funds being used.
Thank you. Okay, so no federal funds being used. Okay, so the next thing that was in testimony is testimony against the RCD9 process. And this process here is not the RCD9 process, Recovery Coordinated Directive 9 process. This is the regular process. So we're not proceeding with the RCD9 process. Can you confirm that one, Mr. Nunakawa?
Yes, I can confirm that this is a separate process. RCD9 process wouldn't come into play unless this failed, then it would be looked at as an option, but it's a completely separate process from this one.
Okay, so this is not the RCD9 process. This is a regular process. Next, sure. You can lift it up or hold it. Oh, did you turn it on?
Button. Okay. I understand that the RCD process isn't this process right now, but the question needs to be asked is, does it even apply if it were the process that was being implemented legally because of the requirements of the RCD, that it pertains to Lahaina recovery? And how does this project pertain to Lahaina recovery? That's the first part. The second part is that it pertains to county-owned lands, and that's in question. So I understand that we're trying not to talk about it as this process, but it does need to be discussed because the reality of whether it comes into play at all needs to be clarified.
Okay, and Permanent Committee Chair Uu Hodgins did put in a request for legal services on that, so we are expecting an answer in writing from Corporation Counsel. To my knowledge, it has not yet been transmitted formally in writing. So we're waiting on it, I guess. So the next thing I wanted to clarify is probably with OEV resources, maybe Dr. Six, if you could clarify for us the HRS 6E process and if we are in alignment with that process or what needs to be done if not.
I'm Aloha Council members. I'm Dr. Janet Six, Principal Archaeologist for the county.
This is movable. So
Yeah, I'm this one like, so I was aware of this process way before the Lahaina fire. So I did site visits, but a 68 because they were using county funds. And so 68 is in compliance. There was an AIS done, an archaeological inventory survey by Scientific Consulting Services, which was approved in 2010. The project footprint changed and it's smaller now. It's a smaller footprint. And I know an additional kapa'akai analysis was done by Kealapono in April 2025, which is not required under 68, but that's just an additional courtesy analysis that was done. And there were 11 trenches put in, and there was one historic property identified, which was a rock wall that probably dated to around the 1940s and 50s when that house was built.
Thank you. And in the Kapa'akai analysis, I think the interview with Miss Taylor, Hiramoto Taylor, identified that their Ohana was aware of a previous, they were aware of Hawaiian burials on the property. Can you speak to that at all?
Yes, actually, Mr. Williams had brought that up before. The parcel is over 20 acres. This is a 6-acre footprint. From what my understanding is they are up the ridge and there are some rock formations that have been identified. This particular project, given its footprint, will not have any real chance to impact those. And extensive trenching was done and no subsurface cultural features were identified.
And I'm not sure if you've looked at Munekio and Hiraga's diagram, but does that even include the water line?
I haven't. I'm actually on vacation. I just was over here for a birthday party. That's if I could come in. But I'm very familiar with the process, and I know that there is. I'm not sure if the AIS covered that or if that would have to be archaeologically monitored. I can't speak to that. Sorry.
The AIS, I think they said they did a what is it called? Pedestrian something where they
Yes.
walked.
Yeah, you walk around and look, see what's above ground. But they
Yeah.
did do 11 trenches, but I don't know if they did it where the utility line is going to go. And I believe that we're gonna call for monitoring. Yeah, I can't, I'm so blind.
Can you
Pass it to me.
hand this to
And
6?
we have been working with the fire department, and OEB has decided if monitoring is required, that we would provide monitors as well as cultural monitors from the Department of OEB Resources. And we've been working with Brad Ventura and the fire department and Mr. Arzumi.
Okay, so in the 1,100-page transmittal from the planning department, it did say that SHPD accepted the archaeological inventory study in 2010.
Mhm.
Is there a need to go back to SHPD to say, are you sure? Are you sure?
Well, it's 16 years old. So oftentimes they will do an addendum to a survey because we have better technologies, different ways. Again, the water line doesn't look like it was part of the survey. So that's the first I'm aware of it where it actually was going to be located. So yeah, so we can do additional testing, especially in a place that hasn't been tested. And we did this with Hawaii the Arts. We did all the testing for the building, but then they went to put the water line. So we went to SHPD and asked what would be required to do that.
Okay, at this point, I wanted to pivot to Mr. Mark Roy. Just a moment. Is this water line that Dr. Six has in her hand, is that the particular water line that SCS did the pedestrian walk on?
Chair, thank you for the question. As Mrs. Six referenced, the AIS was accepted. There has been additional consultation completed with SHPD since. There is an additional comment letter from SHPD in recent years that came up or was issued as part of the completion of the environmental assessment process.
And that was 2024.
Correct. Yep.
Okay.
We
Can
do
you
have-
share that with us?
We can, absolutely. We do have Mike Dago with us from Scientific Consulting Services today. SCS was the firm that completed the archaeological inventory survey. What I would note before we see if Mike is available to maybe respond directly to the chair's question, I will note that I think in the presentation a couple of weeks ago, there was reference to this being quite a long planning process. It's been about 17 years, I think just over actually now. And there was a significant downsizing in the scope of the offsite waterline.
Yeah, I'm aware of that. We can get to it.
Okay.
But right now, just inquiring about the water line, if that was because previously there was going to be a water corridor through a different parcel. And my understanding is in the EA or the final EA, they decided that there was objection to that water corridor through a potential Kuleana parcel and the cost and time. And that's why they were making the water line just to East Kuyaha Road. And my question is, as that water line traverses this parcel, land grant 6553, is that the same water line that was going to also go through the separate parcels?
So my understanding is that the water line, as currently proposed, goes out to, so it goes through the county parcel 008,
Yes.
up to East Kuyaha Road.
Yes.
There it makes a connection to
One of 3 water meters, right? Or something.
an existing county infrastructure.
So my question is, was that the original route that the water corridor parcel was going to go to? Was this route of the water line easement already contemplated by SCS back in 2009? Is it covering the same ground on the county parcel?
I believe it does. We have Mike Daga from SCS here who can maybe clarify the limits of the original AIS, if that would be okay with the chair.
Yes, please. Is that you with your camera on, Mr. Dega?
Yes, good morning.
Good morning. So I'm trying to confirm the waterline easement on the parcel 008 is the same path that was contemplated in the original project where the water corridor was going through different parcels.
Yes, that's correct.
So
I
you
can
did a
read.
pedestrian.
Yeah, we did the pedestrian survey along the entire waterline corridor. Along the east side, it was graded to East Kuyaha Road. We didn't find anything. We also surveyed along Haiku Road. The corridor was cut deep into the gulch. There was basically nothing there. The western extent emerged from Kuyaha Gulch and traversed along Haiku Road to where it met West Kuyaha Road. So yes, we have covered that entire waterline corridor with pedestrian survey.
Thank you. And my apologies, members. I forgot to designate Mr. Mike Dega of SCS Consulting as a resource. Any objections to having him be designated as a resource?
No objections.
Objections.
Thank you. Okay, thank you, Mr. Dega. I guess my next person I would like to call is Mr. Raposa.
Thank you, Chair. My name is Jay Raposa. I'm an SOI qualified archaeologist with the OEV department, and I've been doing cultural resource management archaeology for 11 years, and 6 of them being in the state of Hawaii.
Thank you. I wanted I've been told that you know your way around GPR and LiDAR.
Yes, the latter being doing more GPR. Yeah.
And would those technologies be appropriate on these? I think they said haiku clay and like that. Would those be appropriate or for us to find any kind of anomalies that could potentially be Iwi kupuna burials?
So yeah, so LiDAR would be effective for locating surface features, rock walls, alignments, potential depressions, house bits, habitational sites. And that would be using the LiDAR to cut through foliage, right? So you're looking for surface features. GPR, or ground penetrating radar, could be used. Some sediments work more effectively than others, but it would be a matter of manipulating the GPR receiver and post-processing. So in an area of that sediment, you could still do a survey.
That haiku clay would be okay.
Yeah. One thing to note, though, for your question about burials, it wouldn't necessarily be burials that you would see. You're looking for anomalies of any kind of deposition changes in the sediments. So they would require ground truthing to see what those anomalies may be. Some anomalies could be triggered by rocks or other roots, any kind of natural feature that could hold water, especially.
Okay, thank you.
Oh, correct. Right. Sorry about that. Yeah. So in order to do a GPR survey, you would have to have close contact with the receiver. It's a flat bottom container that you would drag over marked transects underground. So yes, you would need to have a relatively cleared flat area, and any areas that might be uneven or have kind of falling geography or topography would not be able to be accessed as part of that transect or survey.
Have you had an opportunity to do a site visit on this parcel?
I have not yet.
Okay, so yes. Okay, maybe switch it up, Dr. Six.
Jay's amazing. GPR did work in Waihe'e, so it's really a great resource for us. It's very overgrown. I went there with Annalise when she was still with planning, Annalise Kohler, as a site visit. The house was still intact. It was scheduled for demolition. Mike had done, Dr. Daga had done the AIS, and we couldn't even get out of the car. It was, guinea grass. So it would need to be cleared. And then it's kind of a sloping, kind of a rolling terrain. GPR works great at places like Fish Pond, Smokeula, where it's flat. But the one thing is you can't, if it's lumpy, rocky, or you can't move. It's like a lawnmower. You need to be able to like have it in right against the soil. It shoots radar in and looks for resistivity, like if it's looser or more packed, and that's what anomalies will show. So I just want to say, I don't know if it would be a good candidate, but we can go do a site visit. But it's not flat terrain. It's not really.
Okay, and then if they were going to do the water line, they would need to cut the grass anyway.
Yeah.
So, I mean, maybe before we do the water line, we could do a GPR, and if there is anomaly, instead of potentially ground truthing, we could go around it or something.
Well, I think clearing it and then having Jay take a look to see if GPR, because it would also, we don't have our own GPR yet with the county, even though we have a GPR expert. It would probably be Cultural Surveys Hawaii that has GPR on the island. So we'd want to have Trevor or someone come out there as a principal investigator to see if it's doable. We did it at Halau EV Arts, again, flat. We used 100% GPR. So GPR is great, but it's not great for every situation. So we need to do an assessment on that with the contract company that's going to do it.
Okay.
Before we get people's hopes up and then say, oh, we can't.
Okay, thank you. Maybe if I can have Mr. Roy up again. Sorry to make you walk. Last thing before I call up Mr. Williams, we're no longer pursuing those things that you said. Now I'm ready for the rest of the information. We're not having the heliport based on community opposition. We're not having the wind turbines on community opposition. We're not having the water corridor across other separate parcels based on community opposition, cost and time and things like that, if you can confirm that.
Yeah, that's right. There were comments received during the EA process for this project that resulted in the Department of Fire and Public Safety making a decision to remove certain components from the project scope. As Chair summarized, the helipad was one of the substantive components that was removed from this site plan. Also the wind turbines. There were also various other components that added cost to the project, and based on the amount of time that this project has been in the planning process, there was a decision to remove some components from a cost perspective. The water line was a big one. There was quite extensive coordination between the Department of Fire and Public Safety, the Department of Water Supply to determine the current scope of the water line improvements that are proposed. There was a significant reduction in the scope of the off-site water line that went along East Kuiaha Road that Mike Dago was mentioning, all the way up to Haiku Road. Now it's purely confined, to my understanding, to the East Kuiaha Road corridor. I think it's 300 feet of water line that the Department of Water Supply has required, in addition to the connection that I mentioned earlier from the project parcel.
Thank you.
That, to me, summarizes most of the scope.
Thank you. And then Mr. Williams, I'm ready for your input at this time.
Okay. So as far as the burials that are on that property, that has not been included in the AIS that has been done for that TMK, which is the primary issue, is that an AIS was done, but the burials which are marked were not part of that AIS. So it was not an adequate AIS, which means it needs to be redone. That's kind of, as far as the placement of the burials, it's SHPD's responsibility to pinpoint the exact coordinates. It's not the county's responsibility. That's SHPD's fiduciary duty. And then that's not also including the buffer zone of that burial, whatever that is, that needs to be put into the context as far as the project scope.
So my understanding is they didn't do an AIS on the 27.9 parcel because they're not planning on disturbing the 27.9 acres. The AIS was specifically done on the portion that they that we're changing, as well as the water line. So approximately 6.1 acres is where the AIS was for, because that's the portion that's being disturbed.
So I met with SHPD at their office in March of this year with Lenoa Kong and April Greenberg. And what I recall is being shown by April Greenberg, who is the archaeologist for SHPD, or one of them, on her phone, their archaeological records for the parcel, and it mapped out the entire 29 acres. And so the AIS was done for the entirety of the parcel, not just the 6.1 and the water corridor. But it did not include the burials that are marked in the into the AIS.
Okay. And Dr. Six, looks like you have something to contribute. Sure.
So the way an AIS works is you have a project parcel and you have a project area, right? So the AIS is for the scope of work, or we call the area of potential effect, the APE. It's not done for the entire parcel. So again, 27 acres, they did not do an AIS for the 27 acres. Scientific consultant services were hired to do the project area. Now, if the project area changes and gets larger, they will do an additional AIS on that. It got smaller. So I just want to be clear on that.
Okay. Members, any questions up to this point of what we're talking about?
I just want to add also, an AIS wasn't done for the other parcels that were planned for the project. So with the water corridor in its entirety was not done then. So there was no AIS done for the TMKs that were in the gulch, which was where the controversy came up. So that's, if whether or not an AIS was done, there was no consistency in completing the process.
Yeah. So Mr. Dega mentioned the pedestrian survey, but it's kind of a moot point at this point in time because we're not going into those other parcels. So no questions from the other members at this point. You guys are following along with us? Okay. Don't be scared to raise your hand. Okay, I see a hand raised. Member Rollins Fernandez, any comment, question, or clarification to this point in the proceedings?
Mahalo, Chair. I just wanted to clarify what Mr. Williams is saying. So you said that an AS wasn't done in the other areas because it won't be, that's not the project area, or but Mr. Williams was saying that there wasn't anything done for like where the water line's gonna be, and that's in the other
So-
parcels too?
Initially, the project was going to have a water corridor through different TMK or Kuleana lands. And Mr. Dega mentioned that he did a pedestrian survey of that area in 2009. I'm just saying it's kind of a moot point because the water line is contained to this 008 parcel as of today.
Okay, mahalo for that clarification.
Sure thing. Next, I would love to hear
Chair?
from, yes, Member Johnson. Sorry, I didn't see your
Just a
hand.
point of information. I don't see your camera on. I don't know what happened, but in my viewing, I don't see you. I don't know if it's a thing for Sunshine Law.
I see her.
All right, never mind then.
Okay, sorry. At this point, I would love to hear from somebody on from Department of OEV Resources. You guys can decide amongst yourself about native tenant rights to that were never extinguished, how that can be addressed, or what it means, all the things.
Aloha me, mahalo chair for the question. Just more so for clarification in terms of native tenant rights. Did you have any specific?
Well, we know that subject to the rights of native tenants were included in the original Land Commission Awards. And there is also, it's a 27.9 or 28, roughly 28 acre parcel, which if this actions goes through, approximately 21 acres will still be in agriculture and less than fully developed. So what kind of native tenant rights, like could we potentially partner with you folks, Department of Ag, to recognize like native tenant agriculture?
Yeah, mahalo nui for the clarification, Chair. So here's my take from a cultural point of view in terms of Aina, in terms of the land, in terms of the actual usages from a Kanaka perspective. I know that there was some talk about the usage of utilizing Aina as a wahi pu'uhonua kind of concept, where the concept of having a land base that could care for ohana, that could care for Kanaka in different facets. The mindset behind a pu'uhonua kind of ideology is that those concepts were set by Ali'i. They were set because certain kulana or certain kuleana were not always cared for the Kanaka. And so Kanaka took the time to either not abide by and found refuge in Pu'uhonua. Doesn't mean that a Pu'uhonua doesn't have actual ka'ina or references to certain kinds of law within the Pu'uhonua. It just means that it is a place of respite, a place of peace, and a place of growing. And then when Makoko, those folks can then find themselves back into society at the time. That is the general overview of one wahi of a concept of a pu'uhonua. Now pu'uhonua were strategically placed. They were placed in areas that weren't always visited by common folk or the rest of the maka'ainana. There were areas that were off limits to others. And so those kinds of concepts and ideology doesn't necessarily exist in this particular world today that we live in. However, the mana'o behind the apu'uhonua is something that could be considered and should be at least looked at from a Kanaka lens. That if that is something that we're going to uplift, then I believe that the Department of OEV and the Ag Department, is that the other one?
County Ag.
County Ag. Having a good conversation about what that looks like and to uplift that cultural mindset first and foremost, and then how do we make that fit in today's particular society?
Thank you. And in terms of growing of subsistence crops, like does for the native tenant use, does it have to be like all canoe crops, traditional lauhala, or could we do like cucumbers also? Or
I think we live in a time and a place where me'ai is me'ai. In terms of food and in terms of food crop, the more that we can continuously grow and be secure in the food that we have here in Maui, I think is meikai. Matter if it's food crop or native crops that we're looking at.
Thank you. Is Director Stufflebean on the line? Or somebody from the water department? And staff, can we enable? I still see Member Rollins Fernandez, but just pieces of her body. So she's still on. Director Stufflebean, if you can unmute yourself and identify yourself. Or hello? Hello? Okay. Deputy Lillis, are you familiar with the water situation? I read in from Diane something that there's 3 water meters on the process. Are you, or should I ask Diane or Miss Director Stufflebean?
We would likely defer, thank you, Chair, for the question. We would likely defer that to the Water Department or to the consultant for this project.
Okay. If there's somebody named Diane from AECOM or Director Stufflebean, we'd love to hear from you.
Hi, this is Diane Kodama from AECOM.
Hi, sorry, I forgot your last name. I read someplace in the Planning Commission meeting minutes that you said that there's 3 separate water meters.
Yes, there will be 3 water meters, and
one,
it's still in the process of being approved.
okay, and one of the water meters is specifically for the building to provide water for the fire station. Is that correct?
Yes.
And it has sufficient fire flow for that. And then there would also be a 40,000 gallon tank on site for supplemental, like during low pressure or something.
Right.
Okay, thank you. And I see Director Stufflebean. Do we know the capacity of the other 2 meters? Like if we were going to keep the 20 acres in agriculture, could one of the meters be dedicated to doing the agriculture on the other 20 acres for native tenant subsistence living?
Yeah, thank you, Chair. So my understanding is that the 2 meters are designated for the parcel on which the fire station is being built. Here's Jason's here, who's been involved with this. So the question is, is there capacity from the meters for agriculture on the rest of the land? And I believe the answer is no, right?
Yeah, no, I don't think any other use besides the fire department development is anticipated for those meters.
Right.
Okay, can you identify
He should
again
identify- he need to
who
identify
you're speaking to, and we'll designate him as a resource. Hi.
All right, Jason Miyabuchi, one of the district engineers for the Department of Water Supply.
Members, any objection to designating Jason Miyaguchi or Bucci?
Miyabuchi with a B.
Oh, Miyabuchi as a resource to the committee?
No
Okay, go
objections.
ahead. So there's 3 water meters. 2 water meters were for the parcel, that 6.1 acre parcel.
So right now, currently serving that property are 2 5/8 inch water meters.
2 5/8, not 3, because I thought Miss Kodama said there were 3.
So the reservation for those meters for that property occurred all the way back in 2004. So at the time they did reserve 3 meters, the previous owners, which they were going to subdivide. But at some point after that, the county bought the property and it was designated to be for the fire department. So when the meters were actually installed back in 2018, I believe, the way the county code reads is if you're not going to subdivide, we cannot give you more than 1 meter, right? So I think that if I can remember correctly, what happened with the other 2 meters was they were just not used. So that's why the fire department only got the 1 brand new meter off the list, and they already had an existing 5/8 inch meter for the property. So when we ran the new lateral, we ran the new lateral only for those 2 meters.
Can we add more for agricultural purposes?
Add more meters?
Yes.
I mean, the way the code reads right now,
If we were to CPR out the 6.1 approximate acres, could we add more?
everything is dependent upon the priority list. So I would have to say no at this point in time.
Okay. How do we get to a yes?
Well, the issue is the meter list, which is established as in chronological order. So this, if there's a new request, we couldn't really take it right now because it's not on the meter list.
Right now it's closed. It's been
Yeah.
closed since 2013. So we
We
over
can't
the
go-
past few years, we've just been offering and offering, but until a few years ago.
We can't go back to our 2004 placement. No.
So that came off the list already, and those meters, those two other reserve meters, they're, lack of a better term, gone. The offer, I mean,
So what is the total capacity for the 2 5/8 meters on a daily basis?
that I would have to go back to our file. I'm sorry, I don't recall what we did.
Okay, if staff, if we can send a written transmittal for that, what the total capacity is for the 2 5/8 water meters.
I
on a
think we might
daily-
have had a record. Sorry, I think we might have had a record for the one off the list. The existing one, but yeah, I don't know that we have anything off of that. It's just whatever they were using at the time, I guess.
I believe the existing one was confirmed to have enough sufficient fire flow for the fire station. Is that right, Mr. Arisumi?
The existing 2 meters are for the fire station, correct? And then there is a 3rd meter for the water tank itself.
Oh,
So-
okay.
The plans that are currently in maps right now, they show the 2 domestic services to go to feed the fire department development. There's also another lateral that's being installed for the on-site fire system. We call it a fire line with a backflow preventer on it. That might be the one that's serving the on-site tank. I'm not sure. I'd have to dig a little bit more. But those are the 3 services.
Okay, that's what I meant when I asked about the 3 meters, but thank you. We'll send a transmittal to find out the capacity of the 3 meters. Thank you. So everybody okay? Member Rollins Fernandez, you don't need a recess, right?
Yeah, can I get a quick recess, please?
How much minutes would you like? 5 minutes? Okay. So we'll come back at like 10:05. This meeting will be in recess till 10:05.
Thank you.
Will the Housing and Land Use Committee meeting of July 10th return to order? The time is 10:08. The next resource I would like to call on is from Department of Ag. Is that Miss Hunter? Are you available to turn on your microphone?
Aloha, are you able to hear me?
Yes, we can hear you. Is this Miss Hunter?
Aloha, Chair. Good morning. Yes.
I just wanted to know, it seems as though the water situation is a little bit questionable. Would Department of Ag potentially be able to make some agriculture happen here, like with water catchment or excess water from one of the 3 water meters for the remaining acreage?
Speaking on behalf of Deputy Director Heba Heba today, he doesn't have a particular comment at this time. We're open to more conversation with Department of OEB and Water. I know there was some confusion around that this morning listening in. I don't want to say that we can do it without director's immediate approval. So just speaking on behalf of them to say, and we're open to it. I hope that answer can be sufficient.
Have you seen water or agriculture be sufficiently done with catchment water?
Yes, it can be done. We also operate with catchment at KAP. So it definitely can be done with catchment.
Thank you. Okay, so at this time, I'd like to recognize Member Sugimura. Aloha kakayaka.
Good morning. Sorry that I'm late. Thank you.
Okay. So just to catch everyone up that just arrived, no federal funds. The water corridor is staying on this parcel. We have followed the SHIP-T process to date. Dr. Six, can you share with us about the 100% AIS process that would be different if for the water line and the potential to put, since there were no trenches done on the water line, it was just a pedestrian survey, how we could treat it so that it's not an inadvertent fine if during the installation of the water line easement, we don't want to run into EV kupuna.
Yes, I can help clarify that. So what's being required right now, my understanding, would be archaeological monitoring, and fire asked us if we could help, and we can. So in 100% AIS, it's not 100% of the parcel, it's the project area. So say the corridor for the water, they would come in and clear it. And if it's not good for ground penetrating radar and don't decide not to go that route, then we could do 100% AIS, which means we basically monitor, but anything that's encountered is inventoried. It's not inadvertent because we do have Native testimony that there are EV there. We want to take that very seriously. So this would be a way that wouldn't take any additional time, but it would hopefully ensure the lineal and coastal descendants that we have, we're going taking our time. And again, a lot of times you'll see a soil color. Doesn't mean you have to impact the EV because they're likely deeper than the water line. But when you see, whenever you dig a hole and put dirt back in it, it'll be a different color. So we look for soil stains. And if we found that, we would look at the shape. If it's a ovoid cyst, there's oval shape, egg shape, that tends to be pre-contact Native Hawaiian burials. Rectangles are coffins, post-contact, but we have ways of determining that as we go. So that would be my recommendation, to not have any inadvertence, because that area was not tested. There was a pedestrian survey, would be to do the 100% AIS, unless I mentioned OEB would be doing that.
And I'm not sure who I would need to ask, but if we were to come on what we believe could potentially be an EV kupuna, we can move the water line easement to to not impact it.
Absolutely, that would be the intention, is that you would not just go through it, and you would go ahead and redesign.
Mark, Roy, is that your understanding as well as the project consultant? If there were suspicion of EV Kupuna impaction, we can move the water line.
Thank you for the question, Chair. I'm not really considered a qualified expert for archaeological purposes, but we do have Mike Dager from SCS. I think he could respond directly to that question.
No, it's not necessarily about archaeology. It's about if we have a find, which wouldn't be an inadvertent find, it is possible to reroute the water line. That's all I'm asking. Not about archaeology, it's just the water line. It's maybe 3 feet deep. We can move it.
So from an engineering perspective.
Okay, engineering perspective.
Yeah, I believe so. I mean, I'll look to the design team. AECOM is the civil engineer for the design of the water line. If there is a concern, we can share it. But I believe if something was found, there would be.
Who's the engineer person you said again?
Diane Kodama.
Oh, okay. Miss Kodama, that is what we can do. We can move the water line.
Yes, we can move the water line. Then we'd have to do some additional calking, but yeah, it can be moved.
Okay.
Around, yeah.
And Dr. Six, followed by Mr. Williams.
We did this with the parking garage. So we did redesign every time we did impact or locate EV, we did redesign the project. So we do have a precedent there. And it's not a water line, but still it's normal to preserve in place, not disturb them, and change your design.
Okay, so you've done this before. Mr. Williams, you had something?
Okay, I apologize, but we need to backtrack to the prior question about native tenant rights because I'm the native tenant in the room. So first, I want to talk about Pu'uhonua, and I agree with Kapono'ai generally. I'd like to add that Pu'uhonua were established by Kahu. And my family line, my great-great-great-great-grandmother Keauli from Ni'ihau, her line back to Wailua, Kauai, ties directly to Ka'ililao Kekoa, who resided in the Hauola Heiau. Hauola on Kauai is a Pu'uhonua. And the kapu of Ka'ililao Kekoa from her mother Kapua Kalani was called Kapu Akua. That kapu translates to the kapu of the gods. And what it allowed for is the person that had that kapu to either grant life or death upon the word. They allowed to give clemency for those that broke kapu. And that is the kapu that still resides in our blood today. So I say that first because I come from a lineage of Pu'uhonua directly. As far as the native tenant rights, the other part we need to understand is that native tenant rights are very, very specific set of rights. They're not general to everybody. They're not the same as traditional customary practices. They're a very specific set from the kingdom period. So the native tenants were those that applied and resided in the Ahupua'a at the time of the Great Mahele. And whether there's documentation, whether they put in a land claim or they hadn't put in a land claim, or they're in other people's testimonies, those were the native tenants of that ahupua'a. And their descendants are the native tenants. And those native tenant rights apply to that line. So it's not that it applies to everyone who's Hawaiian in a specific ahupua'a. It is the authority of those who have the native tenant rights in that ahupua'a to extend under their rights or our rights, permission for others to come into our ahupua'a and to reside. That's part of our rights to do so. And that's different from traditional customary practices. It's connected, but they're very distinct at the same time. So again, the reason why I'm a native tenant of Kuiaha is not just because I'm Kanaka Maoli. It's not just because I reside in Kuiaha. It's because I descend from a land commission awardee from the Great Mahele, who was a native tenant of Kuiaha. And as you folks know, Shipti has verified that genealogy. Maui Island Burial Council has verified that genealogy and recognized me as a descendant. Those communications has been forwarded to Department of OEB Resources by Lenoa Kong, who's the burial specialist for Shipti. On that note of native tenant rights, this is actually very critical because this pertains to whether or not the county actually has legal standing through the land patent. The land patent 6553 to Florence Wood doesn't have standing because Florence Wood was not a native tenant, and she has no native tenant rights in a parcel that already had a title established. So I'm just going to read from part of my testimony because I'm trying to help you folks as best as I can, because there's very, very real legal ramifications that will affect this county. And I'm trying my best to be very patient and help you folks.
Thank you.
So I'm just going to read this section. So this is point 2 of my written testimony I submitted this morning to you folks. That's on Granicus. Florence Wood was not a native tenant of Kuyaha and had no reserved native tenant rights. Collectively, the May 27th, 1850 Privy Council Resolution, the Royal Patent 383 to Richard Armstrong, and the Land Commission Award 9971 upon a 22 to William Pitt Leleo Hoku reserved native tenant rights of Kuyaha. The May 27th, 1850 Privy Council Resolution concerning William Pitt Leleo Hoku's estate states, quote, provided, however, that nothing in this resolution shall be construed as interfering with the rights of the Land Commission to settle all disputes that may exist as to the title or bounds of any said lands, and further provided that nothing therein contained shall be construed as interfering with the rights of native tenants in said lands, end quote, and that's in Exhibit F. The Royal Patent 383 to Richard Armstrong states in English, quote, rights of common natives in the above land reserved, end quote, and in Olelo, Hawaii states, quote, koe ke kuleano na makaaina na ma kia aina, end quote, Exhibit I. The Land Commission Award 9971 upon a 22 to William Pitt Leleo Hoku states, quote, aka koina e na kuleana o kanaka maloko, end quote, Exhibit L. These reservations of native tenant rights apply to Land Commission awardees such as Nolopi, who is my ancestor, however, do not apply to Florence Wood and subsequently do not apply to the Land Patent 6553 to Florence Wood. And the reason is because indeed from Florence Wood to M.G. Rodriguez, dated December 7th, 1938, and located in Labor 1486, pages 278 through 279, Florence Wood resided in the city of Palo Alto, County of Santa Clara, State of California, Exhibit M. A 1930 census for the city of Palo Alto, County of Santa Clara, State of California, identifies that Florence Wood was age 52 in 1930, born approximately in 1878. The color and race was marked W for white, that she was born in California, that her father was born in South Carolina, and her mother was born in Pennsylvania, and that's in Exhibit N. Florence Wood was a white woman from California, was not a native subject of the Kingdom of Hawaii, had no kuleana land claim registered in Kuiaha with the Land Commission during the Great Mahele, appears in no testimonies for Land Commission awardees in Kuiaha, did not descend from a native tenant of Kuiaha at the time of the Great Mahele, and ultimately was not a Kanaka Maholi or Native Hawaiian. Hence, Florence Wood was not a native tenant of Kuiaha and had no reserved native tenant rights. Land Patent 6553 to Florence Wood, created in 1916, has no valid claim within Kuiaha, as all disputes with regards to title were already settled by the Land Commission during the Great Mahele in the 1850s under the government of the Kingdom of Hawaii. The subject property has been retained under the original instruments that granted title, which are Royal Patent 383 to Richard Armstrong, Land Commission Award 3336 upon a 5 to Nolopi, and Land Commission Award 9971 upon a 22 to William Peleleo Hoku, which from our last meeting, the Department of Corporation Counsel was clear that the title policy for the county for TMK 227007008, policy number 27-31-92-546457 with Fidelity National Title Insurance Company, which is Exhibit A. The Corporation Counsel stated, quote, the policy identified the county's interests as derived from Grant 6553 to Florence Wood by the Territory of Hawaii, and it identified that as the original instrument that granted title, end quote. Nothing in that title insurance policy states that as, quote, the original instrument that granted title. It does state this policy does not insure against loss or damage, and the company will not pay costs, attorney's fees, or expenses which arise by reason of, number 2, any facts, rights, interests, or claims that which are not shown by the public records, end quote, Exhibit A. So the Department of Corporation Counsel's statement at our last meeting functions as an admission that the county does not claim interest derived from any instrument that granted title that predates the creation of the Land Patent 6553 to Florence Wood. That statement duly functions as the department's concurrence with prior written statements by the Department of Corporation Counsel among several other departments that, quote, the agency does not currently possess any records that correspond to your description of the records that you are requesting, end quote, which was from the department's April 7th, 2026 response to a WePro Public's request, where I asked specifically for a chain of title from the land patent 6553 back to the royal patent 383. So what I'm trying to convey to you folks is that your attorneys for the county have already admitted you only claim up to the land patent, and that's it. Nothing else prior that has existed for over 50 years prior to that time. And the insurance policy for the county will not cover if a litigation happens and those claims get brought up. The native tenant rights are important. I am the native tenant in the room. I have I have so much documented in this testimony and that's not the only reason why that land patent doesn't have standing. It doesn't have standing also because the Newlands resolution from 1898 is very, very specific about what lands were transferred over to the United States of America. And those are public lands, government lands, and crown lands. The entire Ahupua'a of Kuyaha did not qualify as those. And I have the exhibits for that. I have the exhibit showing that it wasn't government lands. I have it showing that it was the Leohoku's lands. I have the Privy Council resolution where it affirmed that. I have the royal patents that show Kamehameha III, the crown, signed away his interest to Kuyaha. East Kuyaha, West Kuyaha, signed it away. They're not government lands, they're not crown lands. There are land commission awards, those are private property. Everything is set already. The land patent 6553 does not have standing.
Can you clarify for us your understanding of the Mahele process, of how the Mahele process went?
My understanding is there were Kanaka who resided in the Ahupua'as, right? And depending on the particular native tenant, some resided there for longer periods of time. Some of the Ali'is claimed whole swaths of the Ahupua'a. The native tenants in the Ahupua'a had a lot of the testimonies very specifically say that that claimant had title and it was never disputed, right? So even before they were issued a land commission award and royal patent, they already had title to the land. And that's in all the majority of the testimonies will specifically say that Land Commission Award 3336 to Nalope does have that as well. So each claimant was required to go to the Land Commission to register their claim, not apply for their claim because they already had it. They went to register it to secure it and to ensure that the government of the kingdom would sign over their interest to that tenant. So they had to have their claim. They had to show that they actually resided there. They worked the land. They may have had lo'i. Some of them say, lo'i, kalo, wala patches, kula. They might have a house lot. Just depends on the very specific case by case. They had to have witnesses to come and testify on their behalf to say, yes, that person's claim is true. I know where his lands are. I know the boundaries of his lands. It is true that his title's never been disputed. It's that kind of general language is a lot of times in the testimonies. There's a native testimony, there's a foreign testimony in English, so there's no question about translations. The Land Commission had the responsibility to go through all of the disputes between, because in some situations you have different tenants both fighting for the same parcel. They had to settle the disputes and then issue a Land Commission award to the wardee, and that is where the title is. And then the Crown would issue a royal patent to relinquish the Crown's claim and make it an allodial title. And so that's kind of like a good, general overview.
Yes, that pretty much matches up. I consulted with Kepa Mali of Kumupono Associates. The steps that he went over is one, so this is around 1846 through 1855. One, registration of claims for land commission awards was required. In this, native tenants needed to ask for land that they actively worked and lived on. Two, testimony on individual claims by supporting witnesses was further required as evidence of a particular claimant's residency and cultivation of the land. Three, Mahele Award Book. Upon confirmation of an individual claim, a survey of claimant's aina was required. Then four, royal patents on land commission awards, Kuleana. Final transfer of title to the individual awardees was given. Once a nominal payment for the INA was made or waived, along with and covering the services of surveyors made. Upon receipt of the payment, a royal patent was issued. So the meets and bounds for Nalopi 3336 and 2149 were recorded and covered the 5+ acres as described.
Are you asking me a question for clarification? Sorry.
If we agree on those statements of fact.
I agree, yes, but I would also include that there was a total of 6 apana that belong to Nolopi. And we can go into that deeper to understand that if we need to. But there is a total of 6, 5 of them in Kuyaha, 1 in Pauwela, and that's in the testimonies, and it's on the Land Commission Award document. So there's one that's mapped, which is the Apana 4. That's what's physically mapped and on the drawing. And that's what Kipuka shows generally. And if you compare the mapping of Apana 4 on the actual Land Commission Award to how Kipuka represents it, and you put them in the right orientation to match the orientation, it's very clear that the shapes are not the same. So, and I say that because there is a disclaimer on Kipuka about the meets and bounds as far as how Kipuka represents them. And that's for every Kuleana parcel. In this particular case, it's very easy to see, you compare the two side by side and say, yeah, that the shape's not exactly the same. So that's that as far as the Apana 4. But as I said last meeting, the Apana 5 is what is very important to understand, because Apana 5 expands a very large stretch of land. And I have the documents and I can explain them to you folks.
Okay, so at this time, I guess I'd like members to look at Granicus number 5. And if we can share this with the resource. So in my consultation with Mr. Mali of Kumu Pono Associates, he did email HLU 2194 Palapala Sila Nui from book 9, pages 433 to 434.
Chair,
Yes.
are you going to be like trying to come to an agreement or with Mr. Williams? Is that what the purpose of this is?
Yeah, I would love to find a solution forward that works for everybody's needs.
Okay, but at some point we need verification from our corp counsel. And would that require executive session?
Depending on what you're looking to do, probably. I'd have to know more about what sort of conclusion you were looking for.
Well, if the plan here or the objective today is to work out some kind of compromise, let's say, and therefore a condition to on the property, wouldn't we have to consult you first to hear the other legal explanation?
Yes, probably, and it would probably require some additional research into, depending on what you were looking to do, what sort of conditions you were looking for.
Because I'm just wondering if we should start to go into executive session to hear the other side. Because actually we're just hearing you and him. You know what I mean?
Yeah, as is my right as the chair. I guess at this time, Mr. Nunakawa, did you want to intervene? Is your understanding of the Mahele process similar to what Mr. Williams and I described?
It's similar, but I think that what we were saying related to the title policy isn't exactly what was being represented. What we were saying regarding the title policy is that the title company determined that that land patent was the original instrument. They didn't find any evidence of 383 applying to that specific parcel.
Okay, I guess I would further clarify that. So I think William Pitt Lele Ohoku the first was granted this land, I think, in February of 1848. Is that correct?
He registered his claim to the Ahupua'a of Kuyaha on February, I want to say, was it 14th? Sorry, 1 second. Yeah, February 14th, 1848. So that's when he registered his claim with the Land Commission.
Mr. William Pitt Leleo Hoku the first registered his claim to a number of lands under Land Commission Award 9971, February 14th, 1848. He subsequently passed away December?
That same year.
That same year, later
Not
that
the
same
year after.
September, December-ish. And then, as was previously stated, the lands went to his wife and son, Ke'eli Kolani and John Pitt Kinau Leleo Hoku. Then, and it seems a little shady, but the probate guy was able to purchase 360 acres for $1, which is East Kuyaha.
I can give
August 14, 1850.
So his wife, so the wife of Leleo Hoku sold to Armstrong because Armstrong was involved with the Ali'is. He was the administrator for the estate of Leleo Hoku. And so Ke'eli Kolani is the wife, the widow wife who sold to him for $1.
Sold to him for $1. Later, he transferred the deed to S. Porter Ford, who later transferred the deed to Catherine Lee, wife of First Supreme Court Justice of Hawaii, William Little Lee, no relation to anyone on this council, probably. Different Lee. And then Catherine Lee, who was William Lee's wife, is, as far as we know on paper, William Lee passed away 1858.
I don't recall an exact date. I have his probate, and what I do recall is in his probate, William Lee's probate, there's a will where he quit claims, and it says Lord quit claims the rights that he would have had from Catherine and Lee.
But Catherine and Lee didn't pass away. Only William Lee.
Yes.
Upon William Lee's death, Catherine Lee went back to New York, married the Popular Science founder dude, and liquidated her assets. So,
Can I also interject real quick?
Yeah.
Prior to Richard Armstrong deeding to Porter Ford was the awarding of Land Commission Award. Well, let me actually backtrack further. Was the Royal Patent 383 signed by Kamehameha. So that was given, and there is the notation, see the original papers for deed from Ke'eli Kolani to Limai Kaika Armstrong. Following that Royal Patent issuance, then was Land Commission Award 3336, again with all of the apana. Following that was Land Commission Award 9971 to Apana 22, Ahupua'a of Kuyaha to William Pitt Leleo Hoku. And then was the deeding from Armstrong forward.
So when I looked up Apana 22, there was no royal patent.
Correct. And the reason is because the Privy Council resolution from 1850 explicitly on Leleohoku's estate gave the authority to, and this is not the exact language, you can refer to it in exhibit Exhibit F in my written testimony. It authorized the issuance of royal patents to Kelly Kolani and John Pekinau. So they were allowed to have a royal patent. But because Kelly Kolani sold East Kuyaha to Armstrong, that step was not needed. And so that's why Royal Patent 383 has the notation back to Kelly Kolani's deed to him, because it's connecting the Royal Patent 383 under Richard Armstrong's name to the deed from Kelly Kolani to the Privy Council resolution that authorized her to have a royal patent. So it's, even though Leleohoku doesn't have one under his name, his estate for Kuyaha is directly linked to the Royal Patent 383 to Richard Armstrong, as well as Royal Patent 217 to William L. Lee, which is West Kuyaha.
Okay, and you, Olelo.
Aye.
Okay, so looking at the Palapala Sila Nui for HLU 2194. At the bottom of page 433. It says Oka Apana e Kahi e Lua e Kolu scratches out e Ha e Lima Ame e Ono a Ole I Loa Amai.
Yes, I can see that. And then on the Land Commission Award, which is that third document, which is predates the Royal Patent issuance, it says on Apana 5, Ukuai aku kuai mai me lima I kaika.
And as the process was, it's not a deed until the royal patent was issued.
No, the royal patent is just takes away the Crown's claim to that property. So the title is actually the Land Commission Award. And I can pull up my laptop and go find a federal case where they actually refer to kingdom law about that whole deal. So the Land Commission Award is the title. The Royal Patent 383 is the relinquishing of the Crown's claim to those lands. So on the one part, you have the Royal Patent to Nolopi, right, which is his particular claims. So upon a 4 is the Crown relinquishing of that. But Royal Patent 383 stretches the entirety of East Kuyaha. So the Crown relinquished that as well, which is to the Leleohoku, or to Richard Armstrong, which his title or his document goes back to Leleohoku's estate. And in Leleohoku's Land Commission Award, there is the language which is again the native tenant rights, which means that this set of documents supersedes Leleohoku's estate's claim, because his estate reserved our rights for everything.
Yes. But we're under American law at this time.
Yeah, and American law still follows kingdom law. There's a lot of HRS codes that refer back to Civil Code 1859. And if we're going to talk about American law, I can refer back and I can quote it for you folks, because the Newlands Resolution is actually very key to all of this. So the Newlands Resolution, so this is actually my first point that I want to explain as to why the land patent 6553 to Florence Wood has no standing. So the first point is that the Newlands Resolution 1898 did not transfer the subject property that we're speaking of to the United States, and subsequently the territory of Hawaii had no legal interests. The Newlands Resolution states, quote, whereas the government of the Republic of Hawaii, having in due form signified its consent in the manner provided by its constitution to cede absolutely without reserve to the United States of America all rights of sovereignty of whatsoever kind in and over the Hawaiian lands and their dependencies, and to also cede and transfer to the United States the absolute fee and ownership of all public, government, or crown lands, public buildings or edifices, ports, harbors, military equipment, and all other public property of every kind and description belonging to the government of the Hawaiian Islands, together with every right and appurtenance thereunto pertaining, end quote. And that's Exhibit C in my written testimony. You guys can see the Newlands resolution. That is the epitome of American law, I suppose. It did not include private property. And that's why I keep showing you folks this sign, because the Ahupua of Kuiaha is private property. And and I can go further into that. And because Kuiaha, which is West Kuiaha and East Kuiaha, was private property at the time of the Newlands resolution, the subject property where folks want to build this fire station is still private property, because it did not fit into the requirements of the Newlands resolution, which was public, government, crown lands. So, and I'll go into those more.
Did you go to the Bureau of Conveyances to see who Catherine Lee liquidated her land to?
I have not, but as I've explained with the native tenant rights, it doesn't matter to us because our rights are not extinguished.
Correct.
And so,
my understanding is to fund the Popular Science magazine, she liquidated her assets in Hawaii. So I'm not sure who she liquidated her assets to, if it was Haiku Sugar Company, if it was back to the Crown or whom, but I guess that is what it hinges on. Mr. Nunakawa, do you know what it means with the title insurance? Like, would the insurance allow for a lawyer to be paid to go look to who she liquidated her property to?
It would depend on if it went to a lawsuit. And we believe that even with the exceptions listed, the title policy should still represent if the county brings a claim related to, because the title company didn't identify any 383 interest in that property, which would seemingly be part of a public record. So that exclusion wouldn't necessarily apply. They determined that our interest was back to that land patent, and that they didn't identify any previous interests from 383 on that specific parcel.
So then the insurance would cover a lawyer to defend against a lawsuit and do the research at the Bureau of Conveyances on what happened after Catherine Lee liquidated her assets.
I'm sorry, I'm not familiar enough with how they do things afterwards, but
it wouldn't be corp counsel, it would be the title insurance folks defending the county or defending the title.
I think it would depend. It might be something that we'd hire special counsel for. I'm not exactly sure who would represent the county in that lawsuit.
the title insurance policy says that it's not going to cover any facts, rights, claims, or interests that are not in public record. So it would be a battle between you folks as the county with your insurance company to say that everything I provided to you folks is public record. Whether or not they accept that and whether or not they cover you is another question. But again, I'm trying to help you folks understand how messy this will be.
None of us had an opportunity to go to the Bureau of Conveyance because it's in Oahu. And I think prior to 1975 or 1875, it's paper documents that haven't been digitized. So, I mean, somebody could go and try to track that down.
Yeah, all of these documents that I provided you, a lot of them are from Bureau Conveyance. So the deeds from Richard Armstrong, which is predating the liquidation that you're talking about, that's in Bureau Conveyance. The deed from Porter Ford or his assignees of his estate to Catherine Lee is in the Bureau Conveyance. So anything after that would be there if there was anything. I do want to backtrack because again, the New Zealand resolution is clear about what was transferred and what was not transferred. And it was private property. So as far as the government lands part, I can explain to you why it's not government lands. So William Pitt Liliuhoku registered his claim for the Ahupua'a of Kuiaha on February 14th, 1848 with the Land Commission, which is Exhibit D. The division of land with the government dated May 27, 1850 Privy Council shows that the Ahupua'a of Kuiaha belonged to Liliuhoku and did not belong to the government, Exhibit E. Additionally, the May 27, 1850 Privy Council resolution affirmed this and states, quote, that the division of lands between the government and the widow and heir William Pitt Liliuhoku, deceased this day, submitted to the King and Privy Council, be and is hereby approved, end quote, Exhibit F. So since May 27, 1850, the government of the Kingdom of Hawaii no longer had a legal interest in the Ahupua'a of Kuiaha. So they gave that up and it belonged to Liliuhoku. As far as the Crown, I kind of explained this, but the document number 387 shows that Kamehameha III, who was the crown from 1825 to 1854, held a legal interest in the Ahupua'a of Kuiaha, and that's in Exhibit G. There's also translations for you folks, by the way. However, Royal Patent 217 to William L. Lee, containing the entire Ahupua'a of West Kuiaha, was awarded by Kamehameha III on February 19th, 1850, and shows the signature of Kamehameha. So in awarding Royal Patent 217 to William L. Lee, Kamehameha III, as the crown, relinquished the crown's legal interest in the Ahupua'a of West Kuiaha. So since the date of February 19, 1850, the crown no longer held a legal interest in the Ahupua'a of West Kuiaha. So West Kuiaha didn't qualify as crown lands. And similarly, Royal Patent 383 to Richard Armstrong, containing the entire Ahupua'a of East Kuiaha, was awarded by Kamehameha III on August 14, 1850. Shows the signature of Kamehameha. That's Exhibit I. In awarding Royal Patent 383 to Richard Armstrong, Kamehameha III, as the crown, relinquished the crown's legal interest to the entire Ahupua'a of East Kuiaha. So since August 14, 1850, the crown no longer had a legal interest in the Ahupua'a of East Kuiaha. So by the time the resolution happened in 1898, the crown, it was not qualified as crown lands. So that's the reason why the land patent doesn't qualify. And then the last point is that
just one clarification. So you say Apana 22 reverts back to Ke'eli Kolani and John Pitt Kinau Lelehoku.
So Apana 22 is of 9971 LCA is awarded in the name of William Pitt Liliuhoku. So
the first or the second?
The first. And so because there's a second, which is Liliuokalani's sibling. The first, William Pitt Liliuhoku, he gets his Land Commission award after he dies because the Land Commission is able to do that because the Privy Council says, they can settle the disputes as to titles, blah, 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 blah. So his Land Commission award is the last document after Land Commission Award 3336 to Nalopi, after Royal Patent 383. So it sandwiches everything prior to it and locks in the native tenant rights. So that estate is tied again to Royal Patent 383. Upon a 5 of Land Commission Award 3336 is tied to Limai Kaika, who is Richard Armstrong, Royal Patent 383.
My understanding was Ke'eli Kolani gave a lot of her land to Bishop Estate.
Probably, but not the Ahupua'a of East Kuiaha and West Kuiaha. And those deeds are also, I have that copy of that deed on, actually this is the next section. This was the point about the subject property did not qualify as public lands as required by the Nunes resolution. And I can go there since this is where we're talking about Ke'eli Kolani. So the subject property did not qualify as public lands as required by the Nunes resolution, as Kuiaha was the estate of William Pitt Liliuhoku. The May 27, 1850 Privy Council resolution states, quote, that the Minister of the Interior be and is hereby authorized to grant a royal patent or patents to Luka Ke'eli Kolani, the widow of the said Liliuhoku, for such land as may be apportioned to her as her dower in the estate of said Liliuhoku, and also to grant a royal patent or patents to John Pitt Kina'u, the son and heir of the said Liliuhoku, for such as may be assigned to him and as of his portion of the said estate, provided, however, that nothing in this resolution shall be construed as interfering with the rights of the Land Commission to settle all disputes that may exist as to the title or bounds of any said lands, and further provided that nothing therein shall be construed as interfering with the rights of native tenants in said land, end quote. And that's Exhibit F. Indeed by Ke'eli Kolani and Iowani I'i, dated August 10th, 1850, and located in Liber 4, page 220. Iowani I'i, guardian of John Pitt Kina'u, minor heir of William Pitt Leleohoku, conveyed East Kuyaha to Luka Ke'eli Kolani and West Kuyaha to William L. Lee, derived from interest in Leleohoku's estate in the Ahupua'a Kuyaha. That's Exhibit J. Both of those deeds are on this one page of the other side of the page. Indeed from Ke'eli Kolani to Richard Armstrong, dated August 10th, 1850, and located in Liber 4, page 221. Ke'eli Kolani conveyed her interest in East Kuyaha to Richard Armstrong, Lima Ikaika, Exhibit J. Royal Patent 383 to Richard Armstrong, containing the entire Ahupua'a of East Kuyaha, was awarded by Kamehameha III on August 14th, 1850, and contains the notation, quote, see original papers for deed from Ke'eli Kolani to Lima Ikaika, Armstrong, end quote, showing a direct chain of title to the interests of William Pitt Leleohoku's estate, and that's Exhibit I. On December 2nd, 1852, Nolopi, a native tenant of Kuyaha, was awarded Land Commission Award 3336 to Nolopi, including Apana 5, in addition to Apana 4, which states, quote, Apana 5, will ku'ai aku ku'ai mai me lima kaika, end quote, Exhibit K. Hence, Apana 5 of Land Commission Award 3336 to Nolopi is coextensive with the boundaries of East Kuyaha described in Royal Patent 383 to Richard Armstrong. On January 29th, 1855, Land Commission Award 9971 Apana 2, encompassing the entire Ahupua'a of Kuyaha, was awarded in the name of William Pitt Leleohoku, and that's Exhibit L. The Land Commission settled all disputes with regards to title, the entirety of Kuyaha, including West Kuyaha and East Kuyaha, and therefore the subject property is private property under these directly interconnected original instruments that granted title during the time of the Great Mahele in the 1850s under the government of the Kingdom of Hawaii. So therefore, the subject property wasn't public lands either. So to summarize again, the property that is in East Kuyaha within all of these original titles predating Land Patent 6553 was neither government lands, it was neither crown lands, and it wasn't public lands, it was private property. So it was never conveyed to the United States by the Newlands Resolution, which is the American law. And therefore it was never given to the territory of Hawaii. They didn't have a legal interest to then issue a Land Patent 6553. That's the biggest reason why it doesn't have standing. The law says so.
So some of the readings I did said that something about the right to purchase lease under Part 7 of the Land Act of 1895.
Yes.
It would be government lands.
Who did they purchase it from? The territory of Hawaii, correct? Because that's what the title policy that Corp Counsel mentioned last week. But as I just said, the territory of Hawaii didn't have a legal interest to begin with for the reasons of the Newlands Resolution. So when it created the land patent, they might have created and signed off on it. And I also mentioned that it says right of purchase lease. So not only is it a purchase of a lease, it's a purchase of a lease that had no interest to begin with. And then on top of that, under the Land Act of 1895 that it was made pursuant to, it says under Land Act of 1895 shows that Section 16 of Part 4, and that section is titled Land Patents, states, quote, land patents shall be signed by the President and countersigned by the Minister of the Interior and shall be stamped according to law, which stamp shall be paid by the purchaser, and that's Exhibit P. If you close examination of the Land Patent 6553 to Florence Wood shows no signature by a president, and that's Exhibit O. I provided you folks a copy that I retrieved from the Bureau of Conveyance because I go to the Bureau of Conveyance and research the history of my ahupua'a. And so I provided that folks to you guys, not just in this testimony, but I provided it in the WIPA response, WIPA request I sent to the Department of Corporation Counsel, which they responded to in April 7th of this year. So they've had a copy of that land patent to actually look at it and speak from the facts of the document, but that hasn't happened yet. And so the fact that it doesn't have a president's signature, it wasn't made in compliance with the Land Act of 1895. So that's another reason why it doesn't have standing. There's a lot of reasons why there's no standing for this land patent.
Only to go back to the process that we were talking about, the Mahele process. Step 4 on the Royal Patents on Land Commission Awards of Kuleana, etc., is that the final transfer of title to the individual awardees was given once a nominal payment for the INA along with and covering the services of surveyors was made. Upon receipt of the payment, a royal patent was issued. So there hasn't been a royal patent to 3336 for Apana 5.
We don't need one because it's attached to Richard Armstrong's royal patent. Because his name is Lima Ikaika is on our Land Commission Award document. Lima Ikaika is the same person as Richard Armstrong, and his documents show that. So it's interesting because, again, it's another example where in the absence of a royal patent, a Land Commission Award connects directly to someone else's royal patent under their name. There's all these little nuances that are in these documents if we look at them very, very closely.
So, okay.
And I can even go and explain the boundaries that are in the testimony because I have that as well.
The boundaries
as described for Apana 5, because that's documented as well.
Under
LCA 3336. So I have a copy of, and I didn't submit this as part of this testimony, but I can provide it to you folks as well. I have a copy of the native testimony. You folks can read that. I'll go to the foreign testimonies in English. And so it says, claimant 3336, Nalopi Kapihe.
Is that from January 30th, 1848?
January 30th, 1848. This is
native testimony.
Let me try this file 1 second. July, look like 13th. Yeah, July 13th, July.
1848?
Yes, it should be 1848 because he registered his claim in January of 1848.
Yeah,
and then
I read that one. If you can submit that other one with the boundaries.
Okay, I can do that. So it says this is from Kapihe, which will come in later as well. Kapihe sworn, the claimant's lands are 5 pieces, 3 pieces in the ili of Ululoa, and 2 pieces in the ili of Kupoamoa, in the Ahupua'a of Kuiaha. The claimant received them from his wife in the days of Kamehameha I, and his title has never been disputed.
Kapihe, the wife of Nolopi.
No. Kapihe is the person who testifying on behalf of Nolopi and saying that Nolopi's wife gave the land to Nolopi.
From Kamehameha 1 days.
Yes, he was alive in 1819, which is important historically because this is during the time of the kapu system fully intact. And so that gives you an idea of, 5 parcels in Kuiaha. Who is his wife? Probably someone who was kapu because she had a lot of lands in the Ahupua'a. And also just some other historical facts is that Kalola, who was Keopuolani's grandmother, had lands in Pauwela, which is Apana 6 is also in Pauwela. So the Ali'is, these very high and kapu Ali'is resided in that area. So this is just extra context, but back to the foreign testimony. And then after that, it lists the different Apana. It says number 5 is bounded Mauka by the ili of Lua o Opu, Ko'olau by Pali of Kaupakalua, Makai by the seashore, and Wailuku by Kuiaha. And so the native testimony, it's not a discrepancy, I would say, but it's a little bit extra. The boundaries they say is for Apana 5, Mauka ili o Lua o Opu, Mako'olau Palio Kaupakalua, Makai Palio, where does it say? Oh, Makai says Pali, and Wailuku Palio Kuiaha. So when you put those two together, it's saying from the Pali of Kaupakalua is the western or the eastern boundary, which is the Ko'olau side. The Makai boundary is, in one it says seashore, in the other it says Pali, because if you go to this kai at Kuiaha, the Pali drops down and it's just Pohaku and the kai. So, and I can show you guys a photo of that too. Because so this is actually me standing at Kapuaia Aka, which is the boundary between Kaupakalua and East Kuiaha. And you see all the way in the background is East Kuiaha going all the way to the river mouth which is, here's the river mouth for East Kuyaha. This is the stream that is completely dry at that time. And here's the pali of Kuyaha. So from that is the Makai boundary. Okay. You gotta kind of follow along because, and remember all these little details. I'm sorry if I sound rude. I'm just trying to my best to educate you folks as best as I can. And so the testimony says the Mauka boundary. So we know Kaupakalua, seashore, Kuyaha, the pali going up to the Ili of Lua or Opu. But if we recall from earlier in this testimony, it says that 2 apana are in the Ili of Kupuamoa and 3 are in Ululoloa. Kupuamoa is where apana 4 is, so we know that's one of them. Apana 2 is also there because it says on our land commission award, Ukuai Akukuai Mai Me Kapihe. And if you look in Kapihe's land commission award for his apana 5, you'll see the language, actually, let me quote it verbatim. It says, apana 5, Ilio Ululoloa Kuyaha, Ukuai Akukuai Mai, Okeia Menolopi Ili Okupoamoa. So, apana 2 and apana 4 are both in the Ili of Apana 2 and Apana 4 of Nalopi's LCA are both in the Ili of Kupuamoa. Kupuamoa is where Land Commission Award or the Apana 4 is located, right? So that's Mauka of where the fire station site is. The Ili of Uloloa is Mauka of that. So the other 3 Apana, of which Apana 5 is also in, Apana 5 is in the Ili of Uloloa, okay? So Lua o Opu, if that's the Mauka boundary of Apana 5, Lua o Opu is Mauka of Ululoloa. So from Lua o Opu going back down towards Makai is Apana 5. So that includes the fire station site.
Okay.
And those boundaries are very specifically described in Royal Patent 383.
Thank you. At this time, I think all the background information that we had is out there, and I'd like to open it up for committee discussion. We did put 4 minutes initially, but I think I would like to give you folks up to 5 minutes per member to start the discussion. We still have a majority of the same resources. Dr. Six had to step away. But other than that, the rest of the resources are available. If you had anything to clarify of the background information, or if you had any further questions or discussion. Okay, I see Member Sugimura's hand up. We're going with 5 minutes, yeah.
Thank you. Thank you very much, Mr. Williams, for all that you have presented.
If you can put it closer to your mouth.
Thank you, Mr. Williams, for all that you have presented. What I really want to know is what the administration is saying with the information that he has presented and what is our position for the County of Maui. And I would like to hear from Kapono'ai as well as planning, but more importantly, from Corp Council, as I think Chair Lee also asked earlier. Thank you.
Before you guys answer, and if you can pause the clock. I did speak with fire department, the mayor, OEB resources, but I mean they're here so they can speak for themselves. On the potential of the other 20 acres outside of the fire station as, you know, native tenant ag lands, and they were supportive.
So what does that mean?
That is something that would have to be further discussed and fleshed out with probably OEV, with ag, and with native tenants. He is the native tenant in the room, as he stated. So that was just my baseline. And then you can continue on asking questions that you'd like, and you can resume the time. Go ahead.
Okay, I see Mr. Williams popped up. You want him to say something?
Oh, no, my name.
It's your time to do it as you like.
Yeah, so basically what, if I could then, what you are saying is that the mayor and the fire department is saying to do what with this 20 acres? Is to give it to Mr. Williams?
They were open to a discussion of keeping it in ag and doing ag and native tenants' rights applying.
I can add, as I stated last meeting, the county cannot give me something it doesn't have. I just went verbatim through my testimony that I provided in written for you folks as to why the land patent 6553 has no standing. You cannot give me something that you do not have and that I already have. So as far as native tenant rights and negotiations, personally, my attorneys would need to be present for any negotiations before any of that happens, because I'm not going to negotiate with folks who, I actually, during the Kapolei analysis, I was open to negotiation with, and that's very clear in the recommendations I gave. However, the fire chief, Ventura, in his response to those recommendations, shut them all down. So the county was the one that closed the door on potential negotiations. And so now I'm back, and now we want to negotiate all of a sudden. I find that kind of strange.
So your answer is no, right?
No,
Clearly.
my answer is one, attorneys need to be present. My attorneys need to be present. And on top of that, again, you cannot extinguish my native tenant rights. Whatever decisions you make, I still have my rights. It's not dependent on the county. It's not dependent on whether the county wants to do pu'onua. I have the right by law to assert pu'onua as I did. I have the right to walk anywhere in the East Kuyaha, from Mauka to Makai, because we have the title. Documents, all of them. You cannot extinguish my native tenant rights. They have never been distinguished. My kupuna never sold. We are still alive. We are here still. You cannot extinguish them, because that's where the lawsuit starts.
Okay.
And again, as soon as one dig, that's damages.
Thank you. That's pretty clear. So I would like to request executive session.
Can we give everybody their opportunity to ask whatever they want to ask in open session before we go into executive session, if that's the will of the body? Member Sugimura, are you done with your opportunity? Okay, Charlie.
Mr. Williams, did you say that's where the lawsuit starts? Is there an active lawsuit?
What I meant by that is you folks making an active decision to give me a reason to create a lawsuit, to file a lawsuit, because if you dig, for example, you are damaging the property that does not belong to the county and does belong to our ohana. So it gives me grounds of additional claims, is what I'm saying. And I'm trying to, like I said earlier, I'm trying my best for you folks to prevent that from the county doing that. Because again, your title insurance policy will not cover any damages to the county that come from these earlier rights that you folks said are not on public record. There's nothing on public record. That's your position, that's fine. The insurance policy will not cover it, which means it's going to come out of the county funds, which then potentially might come out of the project funds, which you won't have a fire station at all. I'm trying to give you guys the best opportunity to continue the project elsewhere without us having to do all this mess and without burdening taxpayers.
Okay, well, first of all, we would have to know where in Haiku.
Site D is the other site.
Site D. Okay, and then my other question is, have you filed any lawsuits regarding other properties and won with your arguments that you've presented here today?
I'm in a current active litigation for the parcels that are in the gulch where I live. There's an active litigation right now, which, by the way, I won't give you too much details because, again, it's active. But that started the same month that the Kapolei analysis was completed by the consultants, which to me was kind of strange that the county finishes the Kapolei analysis, looks at my recommendations, shuts them down, and then a lawsuit began to try and push me off of my land.
Okay, the other thing is, my concern is that you're coupling us with the administration. We're not administrators.
Correct.
And so when they closed the door, that didn't mean that we closed the door.
Okay, I understand that.
So you still might be open to negotiation.
I'm not going to say yes or no to that. Very clear my attorneys need to be present if any discussions about future plans of negotiating with the county. I'm pretty clear, again, the county does not have standing. Why would I negotiate with the county when what has the county provided? The county has not done the site visit to the burial sites. That's a red flag to me. They haven't done the AIS for the parcels in the gulch. That's a red flag to me. We're having these discussions about, oh, well, we can rezone the 6 and reserve the rest for native tenants when the 6.1 acres is still my native tenant rights. Like we're circling around the issues of the fact. Again, corporate counsel already admitted through 2 different documents or 1 document and in statements last meeting that there's no claim prior to that land patent 6553 for the county.
I just wanted to clarify that's the UEPA request that you're talking about that we don't have in our possession, but the county hasn't gone to the Bureau of Conveyance.
I believe I submitted that as exhibit. That would be exhibit B in the written testimony.
Of today,
Yes.
that the county doesn't have in their possession.
Yes, that's directly from the Department of Corporation Counsel. And I submitted that also at the June 5th meeting,
And
a regular county meeting.
Nahulu, if you answered that, or whoever answered the UEPA request that we don't have those documents, it's not verification that they don't exist. We haven't gone to the Bureau of Conveyance to track it from Catherine Lee to Florence Wood.
UIPA is really specific in what it requires. So I can't say exactly what research could have been done, but it just means that the county doesn't maintain those records. So at the time of the request, they didn't have any of the documents that were being requested.
In their possession.
Yeah.
But it doesn't mean they don't exist or they could exist. We just don't have them.
It means that whatever was being requested, that department doesn't have them, yes.
And that's why that statement that Corp Counsel said last meeting about the title insurance policy and what it says was supposedly the original instrument that granted title. If that's the case, that the land patent 6553 is the original instrument that granted title for the county's claim, that means that the county doesn't have anything prior to that. If that's what the title insurance policy says for you folks, because otherwise the title insurance policy would have traced further back. Because if there was other lands that were clear, if the county had a clear claim to other land commission or royal patents, I'm sure the title insurance policies would flag that as, yes, the county has those claims. But for some reason, whenever these title insurance companies can't trace a clear chain of title, they just stop in, for example, 1916, because that's where it begins for you folks, as the county. It's
Charlie, I took some of your time. Do you have
Sorry,
more?
I yield.
Okay. Remember Rollins Fernandez said she had to go to the airport. She said she is available by phone. Did anybody else have questions, comments, discussion? Member Cook. Go ahead.
Hello. Hi, Chair. Thank you very much. My question's for you, Mr. Williams. So East Kuyaha, West Kuyaha, at Pineapple Fields, there's a lot of people who live up there. How does the land title ownership address all the residents up there? Are they included in this at all, or is it a separate area that I'm not familiar with?
generally speaking, similar, if they have a similar issue where those folks don't have clear title to these original titles from the Great Mahele, they don't have clear title. And there's families that still have clear title from the time of the Mahele. So that's why we always had these land disputes, is because real estate agencies such as Alexander and Baldwin, for example, historically, which overthrew Queen Liliuokalani in her own kingdom, sell lands that they don't own, and people purchase lands that don't have clear title, and then people settle lands, and we keep getting population booms it's settler colonialism happening in real time for us. So those folks living there, right, in Kuyaha, if they don't have clear title, they don't have clear title. And they don't have the right to infringe on the rights of native tenants of Kuyaha. I would position for those folks, if they want to stop paying taxes to the government, why don't they support the Kuleana families that actually own the property? Because again, royal patents are allodial. There's no reason to be paying taxes on a title that is superior to the government. But
so
those conversations never get had.
Thank you. I guess my follow-up question. Thank you very much. And your research and your presentation is very solid, and I respect you for your diligence. My curiosity is like the tension and the conflict of like people who are paying property tax, and the issues coming up now are pretty huge. And then where does that leave the people? And if they stop paying property tax because, quote, the state doesn't own the property, can't do it, it's like, I guess I'm just trying to see a path forward. Thank you.
Yeah, I can respond to that, because really the vision should be to eliminate the tax map key system, because that's the system of all it is paying taxes on property that someone doesn't own. Because a TMK is not ownership, it's not a title. You can have all of the real property tax records, real property tax assessments, but if that person doesn't have a clear chain of title to the property, they're just paying taxes to the government on something that they don't own. And so, I mean, in honesty, the government should be sued for defrauding people for lands the county doesn't have, or county, state, whoever we're paying taxes to, for defrauding the people, forcing them to pay taxes on property that was already allodial from the time of the kingdom. That's the real issue, is another foreign government in this Hawaiian Islands that has an active, that was never, sovereignty was never extinguished. You hear it verbatim, but we have a different government enacting its laws here in Hawaii, forcing us to pay taxes on properties that this foreign government doesn't have a right to be taxing us to begin with. That's really the crux of it.
Chair, do I have another minute?
I think you have a lot. We had 5 minutes.
Oh, okay, thank you. So thank you, Mr. William. And then so like layering on top of that is people have got loans and mortgages from banks. Like there's a whole stack of, it's not just the government, it's also the, I don't know, it's people working on it, doing it. So I'm looking forward to consider. I'm tongue-tied.
Yeah, maybe it's called the real estate industrial complex. Is real estate agencies, title insurance companies, the banks, and the government all working together to dispossess us Kanaka, specifically us Kanaka, from our lands.
Thank you, sir. I don't have any further questions, Chair. Thank you very much.
Thank you. That just leaves on this committee today Member Johnson or Member Rollins Fernandez for first round.
Thank you, Chair. Having heard everything, I don't have questions. It's just got an aura of sadness around this. There's a lot of history and there's a lot of untying knots of bad decision making that this body has to do. And it's just, I wish we had a clean piece of land. We could put a community servicing facility on it, but that's not the waters in which we swim. We've got all of the history that brought us to this point. So I don't have anything to add to this conversation. It's sad to hear what went down up until now. So I'll wait until we decide what we're going to do. I'll wait to hear from the administration. If we go in executive session, I'm here for it. Thank you, Chair.
Thank you, Member Johnson. Member Rollins Fernandez.
Hello, Chair. I'm in my vehicle alone for sunshine law purposes. I don't have additional questions. I think oftentimes, so this project, as I understand it, was inherited by the chief, and that's just like pushing it forward. And I know how sometimes government invests public dollars into projects and then feel obligated to complete it even after legitimate concerns are raised. And often we're put into this false dichotomy of either having a fire station or a project or not. And that's false. On Molokai, similar to Maui, the east side where there's more water has, more land titles, Kuleana land, royal patent. And when we try to build on undeveloped land, well, not me, but when there was a proposal to build on undeveloped land, it was rejected by our community. And what we ended up doing was just finding a pre-disturbed lot that had a house on it already. And so, like that is another option. It doesn't have to be like a, station. It can be a house with just like a apparatus shelter that's along the highway. And so I think, anyway, just kind of exploring that. Because on Molokai, it wasn't county-owned land that we found. We found, private property, and then, we acquired it and are making it work. And hopefully we're able to open it. Construction will be plowed by the end of this year, and we'll have a fire station on the east side of our island where our firefighters will be safe. Anyway, you all know about that fire station in Ualupu'e, relocating from Puko'o. And, so perhaps instead of like putting all this pressure on our native tenants, dispossessing them of ancestral aina, that we, look into a third option. Anyway, I know, like a site selection happened. I've been part of site selections for the fire station and for a cemetery, so I know how sometimes it's, it's not like the best process. And, we know better now, and we should do better when we're given information for us to do better. Anyway, that's my thoughts right now. I'm sorry. I'm driving.
Can I?
Member Rollins Fernandez, are you going to the airport to come over here to Maui?
Yes. Yes.
Okay, and when are you expecting to arrive over here?
My flight's at 12. I'm running behind schedule, but I hope Mokulele will hold the flight for me. But anyway, to answer your question, sorry, Chair. I should arrive by about like 12:45.
Okay, and you're coming to this meeting?
Yes.
Okay, did you have something you wanted to say to Member Rollins Fernandez?
It's sort of, or just, and then also I guess going back to, I think it was Member Leslie's question about the other site. So there's 3 sites in Kuiaha that were proposed, and there's 1 site outside of Kuiaha. Again, as I've shared, what's the word, ad nauseum, I think that's the word. Our claim is the entirety of East Kuiaha, and all 3 of those sites in Kuiaha are in East Kuiaha. So again, I'm trying to prevent other headbutts later, because I would be back to push back on those other sites as well. The site D is outside of Kuiaha, and I don't have a claim over there. That site D site TMK number is 228006037. And from my understanding, the state of Hawaii claims to own that property. I'm not saying that affirming or whatnot, but that's who you folks would have to deal with. And from my understanding, from all these documents from the state, they're supportive of the project. So I don't see why moving it over to site D and working with the state would be an issue where there's no pushback from the state. Whereas in Kuiaha, there's pushback. there is an alternative site, there's an easier way for the county to accomplish the project, like Member of County Rollins said, that it's not we get a project or we don't get a project. There is a way to get a project without doing it in Kuyaha and trying to interfere with my native tenant rights and also the rights of the other Kuleana families, because not only is it my native tenant rights in that property, but because of our Pana 5, my responsibility is to protect the native tenant rights of the rest of the native tenants as well.
Thank you. For my opportunity, I'd like to call on Mr. Arisumi.
Hello.
Hi.
Sorry.
Are you able to speak on the feasibility study for Lot D?
I'm not.
Oh, okay. Is there someone here of our resources, maybe Mr. Roy? Or you can direct traffic amongst the rest of the resources.
I wasn't a part of that study.
Who's speaking, please?
I'm sorry, this is Michael Arisumi.
Oh, still, yeah. Okay, go ahead.
Yeah, I wasn't a part of that. I've only been involved in this site, so
Okay, we're gonna call
I'd have to
Mr.
get
Roy.
back to you.
Thank you, Mr. Arisumi. We'll call on Mr. Roy to see if he can address the feasibility study and Site D for the members.
Chair, thank you for the question. I'll try and speak into the mic here. There was a feasibility study completed during the environmental assessment process for this project. As I mentioned earlier and at the previous meeting, this has been a long-standing project, over 17 years. I recall back in 2012, during the Maui Island plan process, the council decided to place this project site within the rural growth boundary of the Maui Island plan. I mention that because that's quite unique in this area of Haiku and the surrounding lands. There are no other equivalent sites that fall within the rural growth boundary under the Maui Island plan. So that was one of the considerations that was looked at as part of the feasibility study. There were multiple sites, and as has been mentioned today, that were evaluated in that feasibility study, all looking at potential locations for the new fire station, essentially building on an earlier site selection process that was done before fire department elected to purchase the site that's
Mr. Roy, I wanted to focus in on Site D and the feasibility of Site D, if we can.
Understand. Site D was looked at in extensive detail by an engineering team, an architectural team, for a number of evaluative considerations. Location, emergency response coverage, parcel size, configuration, access to Hana Highway, road network, infrastructure availability, land ownership, acquisition, design, development constraints, and overall feasibility. The study supported the current site as being the preferred location. The major advantage of this site was it was provided suitable highway access and space for the fire station and its related improvements. In terms of Site D, I think Chief Ventura, as I recall at the previous meeting, had spoken to the constraints of Site D. I also recall that there was some testimony at the previous meeting expressing concern about potential burials at that site too. So
do you recall Chief Ventura's concerns? I think part of it was we didn't own the land. The water tank would have to be on a separate parcel. Do you recall all of his comments?
Yeah, I believe he had mentioned the water tank consideration. There were significant infrastructural requirements to develop that site from what I can recall of the feasibility study. It is owned by the state of Hawaii, so not the county of Maui. That was also a consideration. Developing state-owned lands is not the same process as developing county lands. But the conclusion of the feasibility study was that the Site D didn't seem to offer sufficient advantages to replace it for the preferred site that's currently proposed today. And as such, the fire department decided to proceed with the site that's currently being requested for the land use designations at today's meeting.
And you mentioned about the urban growth boundary because?
Land use entitlements were a key consideration of the feasibility study. So what we did was we had to evaluate each site according to what kind of land use entitlement changes would be required to develop a fire station. So
this body has previously amended the Maui Island Growth Plan, and it seems as though it only requires a public hearing in the district. Was that what you're saying is too difficult? For the reason you brought up the urban growth boundary?
That was one, I was just mentioning it from the standpoint of background. So we're here today to request district boundary amendment, community plan amendment, change in zoning. So those are three designations that are being initiated by the planning director for the project at today's meeting. Another site would involve a needed change to the Maui Island Plan, which is a separate application, separate process that would need to move forward as well. So
another site would need, if we're looking at Site D, we would go back to the Planning Commission, do a Maui Island Plan amendment, district boundary amendment, community plan amendment, and zoning, change in zoning, as well as a new AIS, CIA.
If Site D was selected as a preferred location by the fire department from an operational standpoint, which it has not been at this point in time, it would essentially involve starting the entire process from scratch. Pre-design would need to occur to develop a site plan for a new fire station at an alternative location. An environmental assessment would need to be completed for that new project on a new parcel. Following completion of the environmental assessment process, Chair is correct. There would need to be a new set of applications submitted through the planning director, which would be a Maui Island Plan amendment, district boundary amendment, community plan amendment, and change in zoning request. They would go through the planning department review. They would go to the Maui Planning Commission for review, and they would come to this body for review and recommendation, similar to today's meeting. Yeah, it would essentially start the process from square one.
Thank you. So given that we expect Member Rollins Fernandez up approximately 12:45-ish, and that she's coming to Maui to join this meeting, I wanted to survey members and resources, maybe not all the resources, just the resources that we would need if somebody wants to go into executive session, about taking a lunch now and then coming back into this committee for the purpose of going into executive session to consult with the lawyer. Is that what you wanted to do, Member Sugimura? Okay.
Let me try that again. I do want to hear from Corp Counsel, yeah.
Closer to your mouth.
I do want to hear from Corp Counsel, but I also want to hear from Planning and OEV.
Okay. I don't know that we can go into executive session to hear from Planning and OEV. So why don't you ask Planning and OEV your questions in open session, And then when we return from lunch, we can go into executive session to consult with a lawyer, unless staff knows another reason why we would go into executive session. It's just to consult with the lawyer in this case. There's no active negotiation, so that wouldn't be a reason. So at this time, any questions that you have for planning, OEV, or any of the resources that could be had in executive session, unless you wanted to yield to Member Johnson. But from my understanding, the only reason we would be able to go into executive session is to consult with the lawyer, which is Mr. Nunokawa right now.
Okay, actually, when I first started my questions, I did want to hear from them, but I deferred to Mr. Nunokawa based upon what I heard from Mr. Williams.
Okay, you want to go right now for?
I would love to hear
okay.
What
Start your
OEV
time
as
from now.
well as planning has to say, or any of the other departments. But since you're sitting here and have heard Mr. Williams, I just wanted to hear what you have to say, as well as, I mean, both your departments. And if there's anybody else who would like to chime in, that's fine.
We have water, but I don't know that.
Yeah,
that would be appropriate.
I heard. I was listening as I was driving down from Kula, and you're trying to figure out how to spell Jake Mabari Mikar. No, Miyabuchi's name. So that part. So not one.
Say not spell, but okay. So if you'd like to ask, so in open session, Member Sugimura is asking OEV and planning their response to what Mr. Williams asserted, and you can start her time now. Sorry, Mr. Stackhouse, go ahead.
Thank you, Chair, and thank you, Member Sugimura. So from the Department of Planning, I just wanted to point out from HRS Section 46-4, it specifically notes that zoning is a legislative action. So that is the function of this council to bring forth the final recommendation on changes of zoning. So that's within your folks' purview. And so within the charter, it further provides that the planning director shall prepare, administer, and enforce zoning ordinances, zoning maps, and regulations, and any amendments or modifications thereto. So from our perspective, we can prepare those zoning ordinances, which we've done today. And then we understand that zoning ordinances are a legislative action. And so council, regardless of ownership of a property, is the authority over zoning. So regardless of who owns this property, you may zone. And if this was a different property, you guys are the zoning authority from that perspective. So we have analyzed this property and have made land use recommendations only in that regard, regardless of ownership. So that is our commentary as it relates to your authority to zone properties regardless of ownership.
So the planning department, basically you're standing by whatever was presented and doesn't matter what Mr. Williams has said. Maybe doesn't matter is the wrong word, but it's like additional information.
It is additional information that we will not opine on because we are not land ownership experts in that regard.
Okay, thank you. And Kapono, I.
Hello, Member Sugimura. You know, when you asked the question, I was trying to figure out how would I answer this question, either from the department point of view as a director or as a Kanaka listening to another Kanaka in his response, and making sure that the information heard was clear, was concise. Or Kanami, would you like me to pause?
We're gonna have to call recess if you leave. You gotta be on camera. You want water? There's a water cooler here. Oh.
Sure.
We'll have to call recess if we run short of. Okay. Okay. Sorry, Miss Director Molitao.
Kanami, just trying to regroup my train of thought here.
I'm so sorry.
That's okay. So just from a Kanaka listening to another Kanaka in terms of their kuleana, their tenant rights, as well as their rights to the island space. Never will I go ahead and object to any of that, or never will I go ahead and stand in opposition to the native tenant right of the Aina. That is my perspective as a Kanaka for the space. The kuleana of the Department of OEV is to be able to uplift those natural and cultural resources as well. That is the stance of this department. And again, we're here to be able to listen, to be able to help navigate, and to be able to lift those particular areas of expertise. Nothing more to opine on that.
If I may
Think
respond.
about what you said, but, and then I'll just wait for,
Did you want to hear from Mr. Williams as well?
I wanted to hear from the
Them too.
administration based upon your opening and then Corp Council, was where I ended up last. So I just want to hear what they have to say based upon they've listened to Mr. Williams.
Okay, so you're done with your opportunity. Okay, I'm gonna go to Member Johnson for your opportunity.
Thank you, Chair. I'm just going to ask to be excused for the afternoon meeting at 1:30. I have a meeting with MEMA to oversee some legislation we're working on, so I won't be here. I hope that doesn't jam up quorum. It seems like everybody will be here to get the quorum, but I can't make that 1:30, just FYI. Thank you.
Will we have 5 members to go into quorum at one? Member Cook.
I can work from 2 to 3:30. I have a 3:30 meeting, but or actually I could be here like 1:45 to 3.
1:45 to 3. Member Lee.
Yeah, I get squeak 3:15, Chair.
I have a meeting at 12 o'clock, but after that, it's from 1:30 on, I'm free the whole afternoon.
Okay, Member Sugimura. Available. Okay, Member Rollins Fernandez. Go ahead.
Hello, Chair. And for sunshine law purposes, I'm at a public place, the Milka Airport. It can be an executive session. When I arrive, I can go straight there and be an executive session. I do have a meeting at 2 that I have to be. I don't need to go into executive session. So if there's just like 1 or 2 folks that need to talk to the attorneys, they can do it, without having a quorum and going into executive session. It sounds like just member Sugimura needs to talk to the attorneys. So if she wants to talk to the attorney, she can do it during the recess. As a policymaker myself, I didn't get onto the council to dispossess Kanaka of Aina, and that's my policy. And so, similar to what our director of OEB resources said, I will not support anything that dispossess Kanaka of ancestral Aina. What I said earlier was, another option, not on the site selection of D, because I know site D had some problems, but like we did on Molokai, we can just buy one house. We just buy one house. You don't have to do an EIS. What the RCD says that we can do it. We're gonna amend the code so that we can do it, and so let's just do it that way. It's faster. It's already built, and then they'll have a fire station immediately. We just got to build an apparatus shelter. Mahalo, Chair.
Thank you. Member Cook, did you have your hand up?
Yes, thank you, Chair. I would like to go in Corp Council and executive session when we return.
Okay, it looks like we have from 1:45 to 2 p.m. where we have 5 members. So, because Member Cook said he's available from 1:45, and Member Rollins said she's available till 2 p.m. And Member Johnson said he's not available this afternoon. And we know that Member Sinensi, Member Hodgins, and Member Batangan are excused. So there's 9 of us. And by doing math, that's what I come to.
Mick Johnson's changing his mind.
Member Johnson.
Can you recess from or come back 1:30 or I'm sorry, 1:00 too, and that would allow everybody who's there. I'll have to leave, but if I leave middle, then it jams up, right? If I leave in the middle of well,
Not
either
if
way, I
you're
think 1 to 2
virtual.
you
If
have
you're virtual, you can just drop off.
okay, 1 to 2 is I think you would have quorum.
Do we have 5 members for 1 to 2? Member Cook.
Yeah, Chair, I can make 1 to 2.
Okay, can everybody do 1 p.m. to 2 p.m.?
Yes.
Okay, so can we come back in executive session, or we would have to come back in regular session and then go into executive session?
Chair, my understanding is if the body votes on executive session and recesses, you could recess to 1 o'clock and reconvene the exec session at that and convene an exec session at that time.
Okay. Would somebody like to make a motion to go into executive session at 1 o'clock?
So
For the
moved.
purposes of consulting with a lawyer. Moved by Member Lee, second by
Member Cook.
Member Cook. If I could have staff say the lawyer reason for going into executive session.
Yes, Chair, this would be under Section 92584 of the Hawaii Revised Statutes to consult with legal counsel on the rights, duties, and liabilities of the council and its committee.
Okay, and so the plan is to recess now about 11:50-ish, 12-ish, 11:50 when I bang the wood, and then reconvene at 1 o'clock in person in this room. If you're virtual, stay on this link and staff will move you to the virtual executive session. And then when we adjourn executive session, we can come back into the recessed meeting. Is that all?
Chair would need to announce who would be present for the executive meeting.
Okay.
Both in terms of the council members as well as the resource people.
Thank you. So in terms of the council members in executive session would be myself, Tamara Paulton, committee member Yukile Sugimura, committee member Tom Cook, committee member Alice Lee, committee member Gabe Johnson, committee member Keani Rollins Fernandez, as well as legislative attorney Carla Nakata, committee secretary Jennifer Yamashita, and Deputy Corporation Counsel Nahulu Nunokawa.
Chair, there might be 2 more attorneys from our office that would be helpful in the conversation. I'm checking with them right now if they could be online for or in person for that.
Okay, and then Member Johnson, you had your hand up.
Excuse me, Chair, could we get the names of the Deputy Corp Counsel who will be joining?
Okay, he's furiously typing.
While we wait for that, Chair, just to let everybody clarify, I want to be clear that I wanna leave halfway through at 1:30. I gotta go to another meeting. So just on the record. Thank you, Chair.
Thank you. And you're gonna be virtually in executive session?
Yes, so just like you said, move me over. I'll be there from 1 to
When you have
1:30.
to leave, drop the meeting. Okay. So we won't need to recess executive session to let you out.
Okay, great.
It seems like both of them can be on for portions of it. It would be Attorney Deputy Catherine Hall and Deputy Nancy Zhao.
Deputy Corp Counsel Catherine Hall and Deputy Corp Counsel Nancy Zhao will be in executive session. Anything more else I gotta say? Okay, so we will be recessing this. Oh, sorry. All those in favor with that plan of executive session, raise your hand and say aye.
Aye.
Chair, you have 6 ayes, no nos, 3 excused. Committee Chair Hodgins, Vice Chair Batangan, and Councilmember Senensi.
Okay, so now I'd like to go into recess. We'll reconvene at 1 o'clock in executive session. The time for recess is 11:53. 11:53. We'll come back at 1 o'clock, either in the same Teams link and you'll get moved over, or in person in the Kalanapakui Planning Conference Room.
Thank you, Chair.
Will the recess meeting of July 29 that was recessed to August 10 come to order? The time is 2:26. We adjourned that executive session. We're gonna recess this open meeting to August 24th. Same physical location, same Microsoft Teams link, 9:00 a.m. And at that time, because the lawyer had to leave executive session, we probably will go back into executive session to consult with the lawyer and for anyone who missed executive session to hear what is said. So this meeting is in recess till August 24th, 9 a.m. Same Microsoft Teams link, same physical location. Dang it.
Yes, just to clarify, I guess the same physical location as the KP conference room here, Kalamba Quake conference room.
Okay. All right. And this meeting is in recess at 2:27.
Thank you, Gabe.